Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Hey, we're going to go back through. We have finally gone through some of the plaintiffs' proposed findings in the Illinois assault weapon ban case taking place down in the Southern District of Illinois. The case we're going to be talking about specifically today is the named lead case, that is Barnett v. Raoul. We're going to talk about findings of fact and conclusions of law. How important are they? They're immensely important. Why are they? We're going to explain that. And what does the plaintiffs want here, specifically the gun owners of America? What do they want in their findings? We're going to go through all of that as well. So today, let's spend a few minutes and let's talk about this is how you get an assault weapon ban overturned. Okay, hey, before we get going too far down the road we're going down, just proud to announce that this video is being brought to you by the Sonoran Desert Institute. That's right, arm yourself with education, launch your career through education, and most importantly, defend the inalienable rights of millions and millions of Americans nationwide through education. If you're finally ready to launch your career in the firearm industry, check out Sonoran Desert Institute right there at sdi.edu or check them out in the description box below. Okay, America and Illinois, what we're talking about today is the proposed findings of fact and conclusions of law in the matter of Barnett v. Raoul, which of course has been consolidated with many other cases, some of which we've talked about quite a bit, some of which we talked about a little bit. They are all challenges to Illinois' assault weapon ban, known as PICA, the Protect Illinois Communities Act. Now, let's just geek out for a little bit on what are findings of fact and conclusions of law. Well, after you finish a long, drawn-out trial, which this process has been, in fact, if you go all the way back to the very beginning, this thing's been going on for a year and a half now. Now, when the court makes its final determination, what the court needs to do first is make findings of fact. That is, I believe, if I'm the judge, I believe the evidence has shown the following, okay? And that's very important because what you will see on appellate courts, especially those that are hell-bent on upholding civilian disarmament legislation, is they will, in fact, find that the record was insufficient, the findings of fact were insufficient, and out we go. Then in addition to determining what the evidence meant and what you believe, then the judge will take that evidence and apply it to the applicable law and give us his conclusions of law. What parties on both sides will do is they will draft their proposed findings of fact and conclusions of law, or what we like to call, in a perfect world, this is exactly how the court is going to rule. What we're going to do is take a look at the plaintiff's proposed findings of fact and conclusions of law in the lead case, Barnett v. Raoul. This is prepared by the good folks over at the Gun Owners of America. And let's get right to it. The findings of fact, that is the evidence that they are asking the court to find. And by the way, I should point out at the very beginning of this, everything that the GOA is asking, everything that the plaintiff's asking here is kind of common sense, it's kind of duh type material, okay? But these are the findings of fact for which the plaintiffs here want the court to find. 1. PICA bans a large swath of rifles, pistols, and shotguns, which it actually does. Next, plaintiffs are injured by PICA's prohibitions in several ways. Okay, and then the plaintiffs here can fall into one of two categories. There are the FFLs, and there is clearly identifiable damages there, which is in loss in sales, loss of revenue, and ability to even stay open. And then for the end-use consumer, like you and me, yeah, there is the inability to obtain an instrument which we are constitutionally entitled to get in defense of ourselves or others. There are more findings that they want, including firearms and ammunition feeding devices that PICA bans are arms that ordinary people would and do keep at home for lawful purposes, including self-defense, which comes directly from the Heller case. And yes, there are millions of individuals nationwide, and I'm sure hundreds and thousands of individuals in the state of Illinois who owns these feeding devices, or what we like to call magazines, and firearms and accessories, and even ammunition, perhaps, for lawful reasons such as self-defense. The features that render a rifle, pistol, or shotgun an assault weapon under PICA are useful for civilian self-defense. Yeah, that's right. Anything that the state argues makes the firearm more deadly because it is then easier to use and handle by the user also translates to the firearm becomes more effective for self-defense, which is exactly the point that the plaintiffs are making here. PICA bans rifles that ordinary people would keep and do keep at home for self-defense and other lawful purposes. The modern sporting rifle is in fact the most commonly owned long gun in America. It is owned for many lawful purposes, self-defense being one of them. The rifles that PICA bans are suitable for civilian self-defense and thus are arms that ordinary people would keep at home for the purpose of self-defense. That is true, but let us remember that there's a lot more at stake here than just rifles, isn't there? Because another finding of fact that the plaintiffs want is PICA bans pistols and shotguns that ordinary people would keep and do keep at home for self-defense and other lawful purposes. That also is exactly true. And then, of course, there are the feeding devices, or what we like to call magazines. And as the plaintiffs point out, another finding that needs to be entered here is PICA bans, as large capacity ammunition feeding devices, detachable magazines that ordinary people would keep and do keep at home for self-defense and other lawful purposes. That is true. And then these are really important because we kind of know where the Seventh Circuit wants to hang their hat here. Okay, and it's this whole, well, these are military-style weapons. No, a very critical finding of fact that the plaintiffs need here is the common arms PICA bans are not exclusively or predominantly used by the military or exclusively or predominantly useful for military purposes. The firearms that PICA bans lack automatic fire capability. And yes, for that reason, are not used by any military anywhere on the planet. Which, of course, then leads GOA to also point out another finding is no military in the world is known to use any of the firearms PICA bans for combat or any semi-automatic only rifle. And then also important, especially as it relates to the magazine capacity issue. The firearms and feeding devices PICA bans are distinguishable from military-grade weapons in several important respects. Modern sporting rifles are not remotely equivalent to machine guns or other military arms. And then, of course, the plaintiffs also offer their proposed conclusions of law. That is, what does the law specifically stand for so that when we combine the acceptable facts and the acceptable law, we come to the conclusion. And so the conclusions of law that GOA is proposing here are as follows. The firearms and feeding devices that PICA outlaws are arms. I know that seems like kind of a oh duh moment, but you got to remember that we have seen many courts already say, hey, listen, the Second Amendment is not even applicable here, and they do that because then it relieves the government of any type of historical burden of proof. And because modern bans of modern firearms lack any historical analogs or support whatsoever, the Gun Owners of America rightly points out another conclusion of law should be no historical tradition justifies PICA. That's exactly true. As a matter of fact, the only types of firearms that we ever have had a historical tradition of allowing a ban on are those that are both dangerous and unusual. And clearly, the number of these types of firearms that are in circulation, not only in the state of Illinois, but nationwide, makes them far, far from unusual. And then, of course, obviously, GOA points out the arms PICA bans are not dangerous and unusual. And this is really important here because the test is dangerous and unusual, or what we call in common use, okay? It's not in common use for self-defense. The courts want to use that because then it allows them to basically work around the numerical value that would otherwise answer that equation. And so GOA wisely points out here, in determining whether an arm is in common use, the primary question is whether it is typically possessed by law-abiding citizens for lawful purposes, including self-defense. Courts thus need not ask how frequently people fire an arm to ward off an attack. All that matters is whether they typically keep and bear that arm for lawful purposes like self-defense. All of which is totally true. Another very important conclusion of law that the court needs to make is defendants have identified no American historical tradition of banning semi-automatic firearms or feeding devices that law-abiding citizens own for lawful purposes. But of course, isn't this more of a modern societal problem? Maybe something that requires a more nuanced approach? Maybe we can get some history which is relevantly similar, somewhere kind of in the ballpark? Well, certainly that's an argument that the state of Illinois is making. How does GOA respond to that? Well, they propose the following conclusion of law. PICA is not justified by unprecedented societal concerns or dramatic technological changes. And interestingly and sadly, the United States has a long, rich history of having to deal with public shootings, mass shootings going way back into the late 1700s and moving forward. This is unfortunately not a new problem for us. So is a more nuanced approach what's required here? Is something kind of relevantly similar all that's required? Well, GOA very wisely also points out the state's plea for a more nuanced approach is therefore unavailing, but in all events would not help its cause anyway, since it has not identified anything close to a historical tradition of banning arms that are commonly kept and borne for lawful purposes like self-defense. That's right, you must come up with some law that is at least relevantly similar, and they can find none. Okay, the case once again is Barnett v. Raoul. There is hundreds of pages already that have been filed by the named plaintiffs, and then there are thousands of pages which has been already filed by the state of Illinois. We're going to continue to geek out on it. Anytime we find some nuggets, we'll probably go ahead and do another video about it. Listen, if you got any questions about this or anything else related to what's left of your Second Amendment rights, you guys should know how to get a hold of Washington gun law by now, but if you don't, that's okay. That information's down there in the description box. If you got an idea for a video you want us to do around here, tell us by clicking on that link right there and letting us know. It's probably going to be better than any idea we come up with. If all you ever wanted to do is just subscribe to our newsletter, you could have skipped ahead and just looked at the description box, because all the information on how to do that is right down there. And then finally, and most importantly, let's everyone remember that part of being a lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.